Good afternoon, everyone. This is the Vermont House of Young Commerce and Economic Development. It is Tuesday, March 25th, 2025 at 2 o'clock in the afternoon. So we are back from the floor and caucuses and lunch. And now we'll continue to have discussions on H 342. So we have Judge Volney with us this afternoon to begin those discussions. Good afternoon, Your Honor. Thank you for joining us.
My pleasure. Good afternoon. And for the record, Tom Zonay, Chief Superior Judge.
So we're looking at H 342. I think you've had a chance to look at it in the Judiciary Committee. We're trying, I think our biggest challenge is trying to figure out how we can provide for compliance by the data brokers without creating a windfall for, I think, what's been described as attorneys come swooping in and clogging the courts up with lawsuits and that type of thing. I didn't know if you might have any thoughts of, we've been also talking about how could fines work in this realm as well as a deterrent.
So I think that you're highlighting a very important aspect of the bill, and that is, if you're enacting a bill, the question is, how does it get enforced? The current enforcement mechanism that draft 1.3, that's the draft that I reviewed, brings with it, is it provides for damages as well as injunctive relief. And when you have a claim for damages, the aggrieved party would have to establish that they had some type of damage. There had been earlier drafts of this bill, and I know that the New Jersey version, Daniel's law brings with it a $1,000 damage provision that is put there. This bill does not have that. This bill does bring with it the availability of injunctive relief. And I think it's important to understand that when in Vermont, what injunctive relief is sought, a party has an opportunity to seek what's called a temporary restraining order. A temporary restraining order is issued before there's a notice, an opportunity for the party who the case is filed against to be able to respond to it. When the case is brought, we have a rule, it's called Rule 65 of the Rules of Civil Procedure. And the standard that has to be met at that time is that there is immediate and irreparable injury, loss, or damage that will result to the party unless the court enters this order right away. And there's also, as you've heard, I saw your testimony this morning about this irreparable harm. Well, in the temporary restraining order and the preliminary injunction stage, which is the next phase, a preliminary injunction is before the final order and you get a hearing, but it's still before the parties have done the complete discovery and done the complete preparation. In order to get that, you would need to show that there's a threat of irreparable harm to the movement, the potential harm to the other parties, the likelihood of success on the merits, and the public interest. And so the court has, if an injunction is filed, and in this situation, if this bill were to pass, a party could file and say, we want a temporary restraining order. And if the court decides that there's that immediate need before a hearing and they meet the standard, a court could enter one for up to 14 days. And then the court has to have that hearing, and the court would have to apply the standard that I just talked about for the preliminary injunction. And then, if the court does that, we still haven't finished the case because we still have what we'll call the trial, the final case. And so I point that out because injunctive relief brings with it sometimes multiple hearings. It's not just you file the case and one hearing. Some attorneys may not seek a temporary restraining order or seek a preliminary injunction on notice. Others might. When you get to the final hearing, you don't have to show irreparable harm. You don't have to show that high standard because you're just showing that there's a claim we're making, and we show by a preponderance of the evidence that we have sustained our burden of proof, and that the equitable remedy of injunctive relief, that is the court saying you shall do something or you shall not do something, is the appropriate remedy. And so I point this out because it brings with it the potential for relief, but that relief comes after a number of hearings potentially. And so that is one of the components when you look at the injunctive relief and statute here. I don't have a crystal ball to know how many cases we'll have filed. I don't know the complete scope of it. I expect that the committee has probably heard about Daniel's Law and how many cases were filed in New Jersey. Much larger state. So I don't suspect that we would have quite as many cases filed there, but I believe there was a large number of cases that were filed. If we received a significant number of cases commensurate with even our population of protected parties, it would have an impact on judicial resources, and it would also have an impact on staffing. I believe one of the questions that you asked, Chair, was about a fine setup, a fine system. That's a policy decision. This brings with it, the current statute brings with it the ability for the aggrieved parties to receive some compensation if they can prove damages. If you went to a fine structure, depending on how you would set that up, it could be something that the Attorney General could potentially be responsible for. And keep in mind, the Attorney General, we often see their ability to seek injunctive relief in consumer protection areas. They also have that in, I think one of the more recent bills the legislature enacted allowed the Attorney General to seek injunctive relief for paramilitary training sites. And so there are areas that the legislature as a policy has found that it was appropriate to have the Attorney General do that. And then if you decided to set it up in a mechanism with fines, the policy would be that you set up a fine structure and determine on how that's going to go forward. So is it possible? Absolutely. It's really a matter of what policy the legislature wants to go forward on for how it would like, if it decides to provide this type of remedy.
Question?
Thank you so much for joining us. I'm just curious. So when we're talking about data brokers, like there could be tens or hundreds or thousands of data brokers that might have each of our information or a judge's information or a cop's information that they are selling and exchanging every given day. And so for somebody to, I feel like this setup that we lost kind of like on our original version that went to second reading was that we now have an instance where I don't know how attractive it is. Like, we heard from Professor Lawrence Schultz about private rights of action and privacy law. And she was talking about just like leveraging private industry in order to help people when they're going up against big corporations, basically, who are, outsized. So we heard about an example of a case where it was, the defendant was like one person, one lawyer, and the other side was 85 lawyers. And so thinking about that kind of thing where we're putting people in a situation to have to file potentially, if it's not going to be attractive, force a legal team to help them, then they're potentially having to file multiple incidences for multiple companies, which may or may not be in, which we would actually kind of ruled out that they are in Vermont. So they're in another state. So they have to like track them down, get them served, and then go to court with them potentially over and over and over in order to maybe or maybe not qualify for damages. And in a situation where we're really trying to proactively get people to just have their information hidden so they're not tracked down with pipe bombs and pizza deliveries as we're seeing in the federal news right now. And so I'm just curious about your thoughts on requiring somebody to go through that amount of effort in order to just have their phone number, address taken down from a company that is most likely making money off of that information. They didn't give permission for that entity to have their information. And it's just like a constant market, which people are being subjected to harms and they're asking to not be subjected to harms anymore.
So the testimony in the House Judiciary touched on that issue, I believe. And there was a number of individuals who testified that this bill does not provide, if you will, the protection. It provides an impediment to someone, as you point out, Representative, that from finding out where you live, making it more difficult to send that pizza or to send a bomb or to come to your residence. The question about the cost benefit is a tough one, because if you stop one individual from doing something, that certainly is a significant benefit. But whether you're going to be able to find individuals to bring those cases or not, I can't speak on that with any experience because we haven't had that in Vermont. It certainly appears from the New Jersey Daniels law that and its law has the $1,000 actual damages and attorney's fees. It doesn't appear as though they've had difficulty finding attorneys to take cases down there. And I don't know, one firm, two firms, whatever it may be, but it does appear as though there would be firms who would certainly be interested in pursuing it. There is the fee shifting, so they would get attorney's fees, and that is payment. So it's not as though they're doing it for free or doing it for some low amount. If it's their full attorney fee rate, that may provide, if they believe there's a good case, the incentive to take on cases. But again, I think that would be something that New Jersey would have a much better experience with and have some insight on.
This might not exactly be a question for you, but on the conversation about fees, we've been talking about how fees can sometimes not be as great a deterrent for larger corporations. Have you seen fee structures that have been helpful to deter larger corporations?
I can't say that I have seen anything that I would say absolutely that deters X amount deters a corporation, because as the prior representative noted, there's a lot of companies out there. And so what may be an impact on one smaller company might be a drop in the bucket for another. So I couldn't fairly make an assessment of that. But again, it's going to depend on how many companies there are, what their resources are, how they're going to view it. And that, I think, is an unknown. If I went online now and tried to, and I confess, I did. I went on and said, okay, where's out there? I have no idea who put up what where. And so that's where I think the assignments and the other entities come in to assist to have that done. But I don't know if that's the work of one data broker, 5, 10, 20, I have no idea.
Thank you.
Thanks very much, Judge Herb Olson, Representative Herb Olson Starksville. And so the committee is really, as I think you get the gist, struggling with how to construct a remedy that will be, effective in vindicating the individual right and serves as a deterrent. And, we've tossed around a bunch of different options. Someone that I was talking to, well, I asked him, so, class actions are certainly a way to sort of aggregate, individuals and sort of rectify the imbalance of power, that kind of thing. But it was suggested to me that there were some findings that would need to be made around a class action lawsuit. Commonality was one of the issues that might be an impediment to using that route as a remedy.
If I'm not mistaken, there is a class action currently pending, or there was in New Jersey. If I did my research, when I was reading up on it, I think it involved law enforcement officers who signed on. And I thought I read on the one website, which, as we know, everything on the internet's correct and true. So
Abe Lincoln
take it with a grain of salt. But I thought it said there was 20,000 individuals who signed on. So whether it was 20 or 200 or 2,000, whatever that number may be, it certainly appears that there has been at least a class action filed and one or more moving forward in New Jersey from available information.
So there's a number of, I'm sorry.
I don't know how that turns out. It might be they maybe get dismissed or maybe they're successful.
So the bill covers a number of different categories of covered persons. And I'm thinking about the commonality kind of, finding that needs to be made. Would it make a difference? Some of them are judges, some of them law enforcement, correctional officers. Is that an issue, do you think, around commonality?
I want to be very clear. I cannot give advisory legal opinions.
Yes, I.
That being said, I think I can fairly say that the question is, what is the harm that you're trying? If the harm is the same to all, that your information is up and that you should not have your information up, is there a difference between a law enforcement officer and a judge, or a state employee and a judge? Those are questions the courts would have to assess.
Okay, thank you.
Winnie?
I was just wondering, I know you kind of covered this at the beginning, but I'm just wondering, like, in your mind, how would somebody be able to go through the process of proving harms and damages in order for that bar to actually be met, I guess? And this comes into play on all of our privacy laws, really. And yeah.
So that is, I think, when you look at any damage claim here, that is going to be the critical question. What is the damage? If I send something out and someone doesn't take my name down and my information down, and I file a suit, what's the damage that I have incurred? I would have to establish something. And as I sit here now, I can't think of what the actual damage is. Contrast that with someone who has an individual come to their house, and somehow they can track it down that it came from this data broker who received the notice, and they didn't take the information down, and they broke a window, something that basic, or they smashed a window in your car, did something. That would be maybe you can draw that line, but that is going to be the challenge. I think anytime you have damages on something like this, and that's what's going to take litigation. The parties are going to have to establish, the plaintiff, the aggrieved party, will have to establish this was the damage, and they have to prove that, and the other party will challenge that. But I do think it is, as your question indicated, it's a tough situation to try to establish damage when, if you will, nothing has happened.
Thank you, Monique. Thank you, Monique. A question that I have actually relates to that. It has to do with the amount of days that we've baked in. We sort of were thinking of a curing process, giving ample time. Does the amount of time that we're giving have any implications for the amount of harm that could be being done? As in, well, it's not 72 hours. Is it? I mean, are we making a judgment there about harm with our time frame?
When you say time frame, you're talking about the 15 days.
Correct.
I think it's fair to say that one of the reasons that you, as a policy, could be considering this bill is because there's a view that every moment information is up on the internet, it provides an opportunity for someone to access it and an opportunity for them to take inappropriate actions based upon that information. And so if that is the analysis that you're employing as a policy, then the longer something is out there, the greater the opportunity for someone to access it and the greater opportunity for someone to use it for inappropriate purposes. So yes, the longer it's out there, I think it certainly brings with it the possibility for more harm, because the reason you want to take it down as a policy, as I understand it, is to prevent the opportunity for access and use and harm.
So if we're going on the kind of the damages trail again, so if it is going to be, in some cases, let's just say, hard to prove damages and actual harm, do you see the potential for liquidated damages to be an effective deterrent or compliance carrot for companies to actually comply with this law?
As I said before, I think it really depends on the company and their financial situation. that would be one rationale employed by the legislature to say, we want to put this here because we think that as a policy, that if someone has to keep paying $1,000 or up to $1,000, that's going to deter them at some point. But I can't opine. I don't have enough information to know if that's actually going to work. There's a federal Fair Debt Collection Practices Act that used to have that type of approach also. It has $1,000 damages. And I actually, in my private practice, many, many years ago, I defended debt collection companies that had that. And I know that the companies I defended didn't want to pay the $1,000. But I wasn't there in their meetings, so I don't know what they told the employees. But I just know what they told me is they didn't want to pay money, so they didn't want to have the violation. So on one hand, it certainly seems as though any outlay of finances could be a deterrent, but whether it actually is in the grand business scheme, I don't know what a data broker makes. I don't, as far as when they sell the data, is it worth it? I don't have that type of information.
Questions for Judge Soleimani?
Let's flip it around a little bit and let's say we make it so that you don't need to have show that there was that you have harm, that it's on, if we were to pass law that says potential harm. Well, explain to me, does that like open the door? Could I say, well, I asked you to take that information down and you didn't, and it hasn't happened yet, but potentially somebody could have looked my name up, killed my wife and 3 sons, and potentially that'd be worth millions and millions of dollars. So you owe me that money.
Trying to avoid giving advisory opinions. In order to collect damages, you have to establish the, I'll say, probability. It's a preponderance of the evidence, which is 50.1%. And so possibility is not 50.1%. And so I would imagine that would be a contested issue. And I don't see, we generally don't see statutes saying that you open up the possibility, if you will, a strict liability. If you're going to do that, you say, here, if you do X, here's what the penalty is. That gets back more like Chair Marcotte mentioned. If you do this, here's the consequence. Boom. We don't have to worry about possibilities, probabilities. We're saying each violation costs X. That's a policy decision for the legislature. And it's clear. It puts everyone on notice what it is. And it, on the example you just gave, then you start getting into how much discovery are the parties going to get into? How many depositions are we going to have? How much of the attorney fees are going to start spinning around and cranking on both sides of the equation to try to determine whether it really is possible or not, or did your data go here or there? And so the further you go in that direction, I think the less likely it is that you're going to have the transparency and predictability that is helpful to tell the companies, if you do X, Y is going to happen.
Can I just get some clarification on that? The further you go in which direction makes it?
Further you say that it could have happened. The fact that you put my name up there, somebody could have gotten it. I don't know when I walk out my door today that someone didn't get my information yesterday and they might be waiting. And so that's what I mean. When you go down that road of that possibility, issues of proof become much more significant.
And setting up, so converse to that, setting up a fee structure that says every violation will cost you X dollars is much more transparent and clear, and everyone knows what to expect.
It could be, yes. I mean, again, that's a policy decision for the legislature. The one is we want the potentially aggrieved party to receive any benefit of this. The other is the fines go to the general fund, or you set up some other structure that you think may be appropriate. The federal system, I know They have federal judges can opt into a program where they can receive home security systems and the monitoring with that. Do you set up a structure like that potentially for protected parties, where they might be able to have that type of direct benefit? Those are all the types of policy decisions that if you went in the fine direction, what do you do with the money? Again, could be general fund. You could come up with something different. That's up to the legislature.
Questions? Judge, thank you for your input. We appreciate it.
My pleasure. Thank you for allowing me to appear remotely this afternoon, and have a great day, everybody.
Thank you,
If
you
you have-
too.
If you have any further questions, please either email or just reach out and I will be happy to address them.
Great. Thank you, appreciate it.
Thank you.
Take care.
You too. David?
Good afternoon.
Hello. Thank you for coming in this afternoon.
To be back with you sooner than I even expected. Congratulations to your good work on our work we did together on H243. I see it passed here, and Ways and Means and the House seems like unanimously, so well done you. David Hall, for your record, Director of Business Services Division at the Office of the Secretary of State. So this is 342, is that correct? All right, I just want to make sure I'm in the right room and the right bill.
Same numbers.
Right, easily confused, right? I'm here to help, and I want to help, so tell me how I can. I know we have a couple of different pathways into this proposal, and I can address those, or I can just start taking your questions, or whatever you would like me to do.
I think it would be good to address the pieces that we have in there. We don't want to do anything without having that discussion with the Secretary of State's office and
Okay,
Section 4.
so I'll start with, so I have draft 1.3 dated today at 8:06. And so there's a couple of places in the middle of the body of the bill, and then on page 9, section 3, form of notice, where the Secretary of State's office is charged with, I think, adopting and publishing, making available to the public user a form of notice that would be the mechanism by which a data broker would be notified that they want their the covered person wants their information removed. So I generally I think we're the fair way to describe our position is neutral on this. It's not hard. I mean, can we figure that out? Sure. Pros and cons, I guess, and obviously it's your choice at the end of the day. From a pro perspective, I see that it would be good to have a standard mechanism, a standard form where anybody who wanted to make this kind of notice and request would have easily identifiable format for that. As you are probably all well aware at this point, data brokers do have a notice registration requirement that comes through the Secretary of State's office. That's retrospective in nature, right? So it's after you have qualified at some point in a calendar year, you've met the definition as a data broker, then your duty is to come back in January of the following year, tell us certain information, including your contact information and email address. So that's a logical nexus to our office. I don't know if I'd say con, but I guess one concern would be the interposition of the state manifested as the Secretary of State, that the state has some official role to play in that request. And I'd take that a step further in a role to play in maybe giving the imprimatur of veracity, if you will. Specifically, what I mean is the way your bill is written, it says there's no pre-verification process required for who is submitting this request. And it also doesn't say, how you identify yourself or which particular information you want removed or just all of it. I'm sure those are things that we could work out, I suppose, in a form. But I guess that's my one place I'd pause and say, it would be potentially concerning if either the data broker from its side or the member or the covered person from their side said, well, it's an official form, adopted and promulgated by the state, and therefore you have to respect it because, it's official, something like that. And really, we're just an intermediary who's provided this form on our website and you've emailed it. So, is that a value add over just a judge emailing them directly? Maybe. But I don't think we have an opposition by any means of adopting a form, of publishing it. That's, we adopt lots and lots of forms for our own filings. So that's, something we're familiar with. I can't say that I can identify another case where we have adopted a form for some sort of third party purpose. And again, that's just the issue I raise of having people not interpret it, falsely, that we are somehow verifying that, yep, this is a judge or this is a police officer or this is a worker, or their family member, or that they're currently or formerly an employee of, whatever enterprise within state government. So those are sort of the way of balance I see. It's pretty straightforward.
Do you need more specificity in the language in order to determine how you set the form up?
I mean, I don't think so. Again, I don't think this is too detailed or too complicated. I mean, I envision it being something like, tell us who you are, what information you've identified, and whether you want some or all of it removed. And then it's up to you to take that form and do what you will with it. So I don't see it as being complicated. Plus, you're still allowed to do it yourself. You don't even have to use the form that we make. So maybe you don't even need to use it, but maybe you take inspiration from it. But it's a good question.
Do you know how many data brokers are registered with the state?
I think we have about 300 in this latest round of registrations since our new system opened. And I don't unfortunately have data on trends, but that includes both new registrants and re-registrants. So that does include people who have been there before and people who are first time. Again, I think I won't say it's a shortcoming, but it's definitely a delayed snapshot of who's practicing in Vermont, who is subject to, meeting that definition and triggers that requirement. Because you could have been a data broker in January of 24 or in December of 24. Either way, you're registering in January of 25. So, there's no perfect mechanism based on the notice sort of registration function we have set up, but that's my about 301.
Would it be difficult for you to provide to those 301 notice that if this were to pass, that this law is on the books?
No, and that is a benefit of our new system, is that we do have we have the contact information of all of those registrants, and we, without me having to pay my vendor $7,000, can build an email that goes to all of them. So that's a big perk of the new construct. So would be pretty straightforward, I think.
Could at least notify the ones that have registered in the state that this law is on the books and giving you notice, and so that you're well aware of what the new law is in Vermont.
Sure. The other piece is the study about public agency compliance, which I will say our office supports looking at that in the context of the study, because There are likely to be implications, and they will hit differently for what level of government you're at and what your practices are, right? Whether it's state or it's municipal, the context of the records. I mean, right now, bear in mind that the Public Records Act doesn't have a clear way for you to exempt this kind of information. And so it is collected, in some circumstances, and others it is posted. Particularly at the local level, people do use their private home address or their email address or phone number, and that could get complicated pretty quickly. And then it's difficult to be able to speak to the scope of the compliance costs for all of these different people it would affect as a public agency. So we think it's a good idea to look at that holistically and understand the nuance of its scope of application. And we're certainly on board with participating in that conversation, both from Visara's perspective and from our public records perspective.
Questions for David? Okay. I'll get out of your head. Thank you, David. Good afternoon.
Good afternoon. For the record, Josh Hanford. I am the Director of Intergovernmental Relations at the Vermont League of Cities and Towns. First time in this committee with you all, and known many of you over the years for other work in state government and housing. So thanks for asking us to come in and give a quick feedback on Section 4 is really all I'm going to discuss in this bill. And much like David said, I think it would be wise to take a look at this before implementing anything. We have some concerns about how this would interact with public records law. As David said, it's just a fact. We collect a lot of that information, have to. There isn't current sort of exemptions for that. It may conflict with some other Title 24 requirements, certain obligations to keep records, marriage licenses, deeds, permits, others that we just don't know how it would all relate. Of course, the feasibility, like what would that take to sort of scrub this or handle it in a way? What are those costs? And, on the flip side, VLCT generally supports transparency in government and folks having access to the records and who's submitting a permit and so forth. So there's a lot to look at in here. Happy to take any questions, but that's really the extent of what I have for you on this to consider.
Mr. Joe?
Yeah, so basically you're saying no to the public agency side of things, because it would conflict with open records and would cause a burden on our municipalities.
I'm saying that a study of how this could move forward, if it is chosen as a policy committee to make this apply to public agencies, is absolutely required before something can be put into law. I'm not making a comment on the policy debate you guys are having, but that these issues do need to be considered before a policy one way or another should move forward.
Better first step to putting the policy into place and then trying to figure it out. Emily?
Do you like, I guess I would say like have any or would promote or be supportive of any exceptions to the open meeting laws? I mean, understanding that transparency is obviously important, especially in such a citizen-led state, but there sometimes may be too.
Absolutely. In fact, we have submitted a number of requests to change and modernize the open meeting law. Some are considered in a bill currently, and hopefully we'll get a chance to discuss it in House GovOps. There's just a lot that's changed, that need to be considered, site visits, especially as we moved from COVID into hybrid meeting requirements that are presenting challenges for folks to comply, as well as Public Records React. We're entering a new place where there are folks generating public records requests to municipalities very frequently. And folks at the local level are put into a situation of trying to understand if those are real people, if they should be complying with them, taking a lot of staff time to comply. And, is it being weaponized at some level? I think there's cases of that across the state. And so we very much support some modernization of good government transparency practices, but understanding we have changed as a society and we need to be doing the right things for the right reasons and responding to legitimate requests as opposed to requests that may be just there for disruption purposes.
So in that agency is meeting, receiving testimony in the study, that's including the LCT, the Municipal Clerks and Treasurers Association. That's not meant to be an exhaustive list, but are there other organizations you think would be thinking of right size for this?
Right. I could think about that. I think you're right. There's probably a lot of other folks that could be consulted and considered here. I don't want to speak on behalf of the clerks and treasurers, but there's a lot of public agencies, RPCs, RDC, there's a whole list that may have a slightly different perspective, slightly different concerns, ability to comply that could be considered here. We certainly, I should have started off with this, the Vermont League of Cities and Towns is a member organization, but all 247 municipalities are members of the LCT by choice. The vast majority, all but 2 or 3, also receive property and casualty insurance through the league. But their villages, not all villages are members. They're sort of a subset of a municipality. And then there's lots of other groups that are considered municipal, fire and water districts and others that I'm not sure how they should or shouldn't comply or would be considered. But we certainly could represent a pretty large group, but there's probably others that could be named here, or it doesn't have to be exhaustive. I think that the parties you put in charge of the study, Secretary of State, Agency of Civil Services, Agency of Administration, could go beyond the group here. Yeah.
Other questions? Okay, Josh, thank you.
Thank you.
Tomorrow, Thursday, we'll hear more from the Agency of Administration, Agency of Digital Services, and also Attorney General's office. But at this point, what are people thinking?
Do I speak again first? Oh, no, please.
I was waiting for you. Well,
I'm obviously the big mouth of the room on this. I'm sorry. I mean, the way that the private right of action has been changed, I think I feel more comfortable about it based on what we reviewed this morning, unless it's changed again. I don't think it has. It was only gone for 4 minutes. And I still maintain I'm concerned about the business to business transactions and the way that information flows between businesses. If you're not part of that process, you may not, understand just how much of an impact or not as much of an impact it would have. However, that being said, if it was put to a vote now, the amendment, I would obviously support the amendment because I think it's closer to where I want to be. But I still don't like the original bill as is. So
Only talking about.
correct, right? No, I know. So So that's where I am on the issue. I still think I think there's more that we could do to fix my problems with the business to business, but how to do that, I'm not positive, absent saying, legitimate business purposes, right? And it's clear that nobody wants to do that. And I get that. But if it came up to a straw vote now, I would support it just because it's closer to where I want to be.
I really appreciate that we've taken time to look through this and consider a lot of the stuff that was in Harvey's amendment, and I am comfortable with everything with the exception of changing the private civil action from 1.3. I just don't think that we're setting people up for success to be able to. I just think we're like the burden we're putting on people at a time when they're really just trying to fight for their safety, basically proactively, before it becomes an issue, where they have somebody showing up or threatening them. And I also just, I think the precedent this sets for other privacy bills we have to consider, and also just thinking about other states. Like if we pass something, that, we're talking about Vermonters, so I want to protect Vermonters, and set them up for success, but also we know from the privacy bills that we end up copying other states, they end up copying us. So if we are pushing out a mechanism that does not help people and puts more of the burden on individual shoulders, then we have also potential for a ripple effect there. So if this came to a straw poll at the moment, I wouldn't support the amendment unless we were going to change back the remedies to 1.3.
So I'm still struggling with how to get effective enforcement mechanism, and we're trying to crack this nut, and we're having trouble with it. The judge's testimony I thought was very helpful for me. He raised a couple of points I hadn't thought about. One is, what an injunction entails, and I should remember this. You guys show irreparable harm in some way, and without him saying it directly, I think he was questioning that it's a real standard that you need to prove, and could you be able to prove it? And I think we were relying on that aspect of it. And so he, I think, raised a legitimate issue around that. He also mentioned, maybe I'm reading too much into his testimony, but he said something in the fact of, he's having trouble thinking of actual damage in these kinds of circumstances, where you don't have, like he said, the broken window or whatever it was. How do you measure damages when the damage is not theoretical, but it's hard to pin down in terms of the amount? I don't know where that leaves me. I'm still looking for, some sort of effective mechanism to enforce and a deterrent. And I'm hoping I'll think of something, and that will might have some testimony on Thursday that will help us out there.
I guess I would say I'm generally supportive, definitely generally supportive. I am also a little bit concerned about just finding a little bit more tighter resolution on the remedies issue. I'm curious to look at the fines more to see what an escalating schedule might look like, and try to figure out if that would have any bearing. I think to your point on the damages thing, I guess I understand how it is hard to sort of pin down actual damages because it's so dependent on a person's individual situation. But I'm also just thinking, part of the reason why this has come to the table is, thinking about the worst case possible, which would be a very clear set of damages. And then I think also just on the daily basis, the level of harassment that we get as citizens with our phones constantly going off with things that are not related to our lives. It's not a big damage, but it may be a petty damage, but maybe there's a little damage in there.
I'm in, I would be a yes vote the way that the bill as it sits. I'm gonna preface what I've said all through this, that I question its effectiveness. I mean, it's like locking your front door, but leaving your screen door and your side door open, because there's so many other ways people can get this data. So I don't know how effective it's going to be. In some ways, I have some concerns whether we're going to lull these people into a false sense of security. Oh, I put this in, I'm safe now. And that's absolutely not the case. I understand where Monique is, and I have a little bit of wiggle room there, but I would not support going back to the way it was in that aspect of it.
I'm still trying to work it out in my mind as well. It seems like the enforcement's not strong enough the way it is. But I don't, and I guess I want to fully understand a little better if there's other better ways to do it. But it seems like if the remedy isn't there to be effective, then I don't know what the point of the bill would be then. So it's not really an answer, except.
I mean, of course, the study for the public agencies. I feel like I like some of the safe harbor pieces. And I feel like if we have a deep enough safe harbor, that anyone who chooses to cross that safe harbor, I'm fine with a full action PRA. Because if they choose to walk through that safe harbor and not take advantage of all the opportunities to do right, then I think a PRA is the only fair solution, both for the people who don't want their data shared, and that there may not be a measurable harm, but they don't want their data shared. And the other piece of that is we have to look at deterrent. And if we don't have something that's deterrent worthy in the bill, then it won't deter. As Representative Harvey said, right? I mean, they'll just put it in their fee structure. They'll just budget for it.
Add something a little more. I mean, the things I'm going to be thinking about before Thursday are, what are our options, in terms of enforcement. I sort of categorized in my mind. I'm not worried about, the liquidated damages kind of issue. That comes up in a lot of situations where it's hard time. You have no time so they can find what the damage, measuring what the damage is. And so I'm not as, and I also looked up the rules around every attorney when they file a pleading, they have to, they're promising that they're not doing this for a malicious purpose. They're not frivolous. And if the court feels they are, they get hammered. I went through it a little bit last night or on the weekend. So that was some comfort. But I also understand that that's an issue, that whole it's an option. So I'm trying to think of other things. I have, like I said, I have a concern around the damages being hard to prove, injunctive relief, how do you show irreparable harm? I'm looking to the AG to a certain extent because she has a number of different statutes. We've told her to enforce, a right. If we create a right, an individual right, and we know there's a great balance of power between, the individual and the company. We say the AG can just step in and sort of represent either on her own or together with the individual. So the individual sometimes gets to do their own thing. Really kind of maybe sort of in this vein about it. It's not they could do it together. And they do this specific statute around Social Security information and how do you keep, so which is kind of analogous to this in a little bit. And we've given them the authority, we've given the AG the authority to enforce it. I said exclusive, but it's not, with the individual, but it's, she could do that. What else was I thinking of? I'm not sure about the class action thing. I couldn't quite sort out what the issues were. But I think those, well, the regulatory agency, that's needs a lot more. Ultimately, I would hope that, either the federal government or maybe a consortium of New England states or whatever would be able to figure something like that, but that's it. That was playing around.
I do need to go back and review Judge Sony's full testimony. I apologize for late getting back. I'm hung up in that I want something that will be effective, but not so burdensome to covered parties like we talked about at lunch, that they're going to say, well, I don't know if I'm going to get the results. Is it worth, paying my, buying the dance card to start the whole process and go from there? So it needs to be, if you will, user-friendly and effective. And to me, that's one reason we would go with since you spoiled me with 243, the harmonized, standardized form for people to use. Sorry about that. But, even if there is no ownership other than just having an official state form, I think that would help carry some weight. And I like that. And I was concerned, and I do still remain concerned about the public records aspect of it. So I'm really solidly behind doing this study with as many of the interested parties as need be assembled, because I know my data's out there just from being here in this room, and whether I'm covered for any other reason, that's another story. But that was a concern of mine from the start. I'm glad to see that still in there. So I'm still processing. Definitely need protection. I think I shared with most of you, there's law enforcement people in my family. And I want to make sure everybody is protected. And I wonder, I share Herb's concern of how does it really get enforced? As I've heard people say, well, these fines you're talking about, that's just a rounding error to some of the bigger operations. And some of the smaller ones, it could be, or some of those that, they're a merchant and they happen to collect data, but they maybe also sell it on the side because they're selling widgets. Anyhow, it's my rant.
It's a Dave's point. I did a little research on fines also over the weekend, and some of the federal agencies that enforce individual rights, SEC, Consumer Finance Protection Bureau. There's one other one I couldn't remember. And they craft them in different ways. They have a fine. They're fairly hefty fines, but they also have tiers depending on culpability. They have a feature around size. So I think you could figure out a fine schedule that made some sense. The problem that I have with it is you can have a fine, but who's going to step forward and take the case for that individual, and prosecute it and end up with a fine? I mean, I think the fine, if it happened, you might be able to figure out a good structure, but that's my worry about the fine issue.
On the fine issue, but you're saying at the federal level, we do have a fine schedule, and to the judge's point, they have fines in New Jersey and they don't seem to have a hard time finding lawyers to take up these cases.
If I get in, I think in the scheme of the bill here and in New Jersey, they had that liquidated damages issue. And the way I look at it, think of a liquidated damages, it's kind of like judicially imposed fine, they serve the same kind of purpose, so they got some amount. But and that's the motive, that's the monetary motivation
Right.
to take the case.
Well, if we have to put that in there for a little sugar, I have no problems.
I had felt a little whiplash. I was excited about where we ended last week, but I thought it was nice to hear the challenge of going the injunction route. And it was a new perspective on harm and the burden that carries. I'm sensitive to the commentary around what is the user mechanism going to be if it's one person scrivening their way through dozens and dozens and dozens of the same thing, just how that might be. I think the concern that maybe that does seem like unapproachable, or that's the deterrent to participation. And so are we looking to try to craft a model that is able to make efficient use of court time and filing time? And is that what we're losing out on with the current language? That's something, so I still want to chew on this a little bit. I'm more okay with this version than initially I sort of was thinking at first, but I'm reading through it and feeling a little bit better with it. But I am looking forward to hearing more from more testimony from other people. I do like the study, and I honestly think the study might help us in subsequent biennia. We respond to things if we were to see have any private sector component of the legislation.
I think what I'm hearing, we're on the same page as we need to make sure there's a deterrent. We're just not sure how to apply something to create that deterrent.
And to get someone to take the case either privately or through a public opinion. That's what I'm doing.
Any thoughts, Rick?
Oh, okay. Didn't see it. Rick Segalwalt to the council. I heard the judge's testimony and David Hall's testimony. I think it's a committed decision as to how you want to deter this conduct. And I think the judge provided some pretty good information about the injunction and about the harm, how it's going to be hard for someone to prove that harm.
And I think what he said, it comes down to when you're told to remove, redact the information and you don't do it, here's the penalty. It's not based on harm, based on you do it, and if you don't, and that's probably what we need to think about.
Some more fine structure.
I think.
I mean, I like fine structures and I love escalating fine structures. So starting off at like $100 a day and slowly reaching up. I mean, and I think I said it this morning, where, you get the 15 days, you got to do it. And then an injunction, or not injunction, but a lawsuit, that's somebody serving you papers. If you're not getting it at 15 days, like, hey, you need to, and you're getting papers. And then 15 days later, you still keep it up there, then yeah, levy those fines and they just escalate. And, we can have the fines that are collected can go into a victims fund. And the interest made on the victims fund can go into the general fund and help us with some of our
there already is things fun. So we wouldn't be making anything new.
I mean. And at the end of the, no,
Just wondering with the fine structure, who, like what gets the lawyer to like take that case? Unless we're saying lawyers are gonna get a percentage of the fine, maybe.
Can we do that?
I wanna say lawyers get 35% of the fines that come out of this or something.
Yeah.
That occurred.
Yeah.
There wouldn't necessarily be lawyers. This would be the state, either the EP or the state's attorney levying a fine, and you get notice of a fine, the business would, that you've been fined, you violated this statute, you owe this much money, and they can hire a lawyer. Like it's when you get a speeding ticket, you know, you get a violation, right?
Yeah.
You are the defendant, you can hire a lawyer. And the state or the municipality that issues the ticket, obviously, if you challenge it, they'll hire a lawyer, you know, to prosecute it, but you know, typically when you issue a fine, as there's no, as I think the judge mentioned this, the fine structure, the covered person will not get remedied, right? So that they lose out on that, but the state would obviously receive the remedy. And I think it's a question as to whether what you think is the better deterrent. Is it the state being able to do this, and do they have the capacity to issue these violations? No. But then, yeah, the other side would be the covered person does not recover money. They may have their information taken down, which is good, but they wouldn't receive any money.
if the state was the maintainer of this form, they would then have the ability to magically email all the businesses, correct? Didn't you just say that you have the ability to?
Only the registered.
9,000 more data brokers. We only had 300 that are registered in Vermont.
There'd have to be a lot of coordination because the cover person would send the notice to the data broker, and then the cover person has to alert whatever state entity is going to administer the fine, the violation. So there'd be, the cover person would be doing a lot of work.
And they wouldn't necessarily get anything, right?
They
The
would
state
not.
would get all the fines, so.
You could do a fine, well, here's something, you can do a fine and you can do a court path. You can do both.
That makes me more comfortable. Honestly.
Both.
Because I keep thinking about, again, I keep going back to traffic. But the idea that there's like a sort of set amount of fines, and then if you are really egregious in your violations, it tips over into a criminal action. I think that, noting to your point, and then I also keep thinking about is the reason why we're talking about this is for the worst possible thing that potentially happen to these folks. And not being able to get any remedy or recourse just feels wrong. And obviously, I know if you know something really terrible happened, there are other laws and things that do kick in. But you know, if you could directly tie like your information being publicly available from the data broker to the potential like loss of life in your family, I think there needs to be some sort of connecting point there.
I feel a little less certain on that. And I'm trying to think of how to, I can't quite figure out why this is on my mind as much as it is, but it's the harm that we're trying to avoid, or the thing we're trying to prevent is publicly, or it's just the availability of information, which is a tough job and a big job. But I think I'm trying to think through the mechanism. I think in a lot of the ways that we're talking about it now is like, so yeah, what is the experience of the covered person? Like what do they do? Who can help them? And that's what we're positing here doesn't seem, like you mentioned, Sharon, that there's like 8,000, and are we signing people up to submit 8,000 of these? Or are we just trying would it just be about the 300 that are in the state? And so I'm wondering if are we hitting this? Are we going at this? I mean, if that is the experience for the individual, are we going about this the wrong way? And or for what law firm is willing to allocate what is the human resources, human hours equivalent that we're talking about here of having to do? If you do it with just one, do you really have to do one for each separate entity? Is that something that you've talked about, Monique? Like having to do this, several iterations of this for each named entity?
I think that's how we set it up. Yeah.
And that's
In the amendment, that's how it's set up. Yeah.
But how is that? And can you tell me how is that not the case before?
Well, so, I mean, I guess is it okay? Okay. I mean, I guess, so I think it's all about attractiveness of having somebody basically come in, like a resource to help that they can hire. So for instance, so we're talking about like good actors, bad actors type of stuff, like if you're going to have somebody that has to like file and it's not attractive enough for a lawyer to come in and help them, then they might do each of those individually. And I don't know how many they can get to and how many they can afford. If you were able to attract somebody that can help do multiple people at once. So that would, and actually like cheaper for a company. And I would think that if you have somebody and say it costs $100 per filer and whatever, and they do 100 of those or something, think about that, and then think about versus one entity doing all of those 100 for not, and the fee for that filing that is going to be less than what it would be for 100 people filing.
So
100 suits.
We're creating something that was both a stick for the bad actors and a carrot for the representation that could assist in an efficient manner. And that,
yeah,
okay.
Which goes to what Warren Schultz said about like we need a private public, kind of like public good private hybrid relationship in order to help people.
So in theory, it should make it easier for the courts to process.
Yeah, exactly. To process one, yeah.
That's lowering the administrative burden of the state.
Yeah, exactly.
In some ways, it feels, I feel better when this is, I know the Attorney General has suggested that that's probably not the best fit is their work, but that it feels like it's sheeting that way for me. However, I guess the thing I'm trying to think through is if we have this, if we treat this if this is being treated as an emergency of exposure of risk, the timetable seems to also be important. And so I wonder, and that's something I'd asked the judge about, was where we provide the harbor as a kind of run up to, like, you're going to get it. We want to give you a chance. We also want to give ourselves the sense that we have been fair and so not rash. Are we also, I think there's also a baked in value there in terms of and maybe nothing really bad has happened yet, except for the availability of the information, which is not, and that's the thing. Are we making an assertion about the issue at hand with our timetable and about its severity, about its immediacy, about the need for relief?
I think you just have to turn on the news this past week to see the immediacy need. Yeah, I don't.
To your point, this is like between the 72 hours versus 15 days.
It's kind of what I'm getting. Yeah.
Yeah.
I think that the safe harbor piece is something that we definitely want to look at and tighten up and make very clear. Because to your point, I think that it's a little bit muddy right now on when a business gets safe harbor and what kind of notice they need. And I think that's going to be an important piece of this too, especially if we can figure out a way to ensure that that there's a method of enforcement that works. So we want both. We want to have a really clear safe harbor. We want to have a really clear method of enforcement that will work in Vermont. I think we're close, but I think we need to tighten things up in our language a little bit. But I was in that same place with the, is the time right? Are we doing this in the way that is really clear and, you know, again, making sure that the business knows what's expected of them, what the value is for them to comply versus what the penalty is for them to not comply.
I think some of the the timeframes that we built in was based on testimony that we heard. That people can't deal with that. In holidays, and here in some jurisdictions are 72 hours. I mean, what are we, you know, we're trying to make that determination of what's a reasonable time frame, what's reasonable for both sides to be able to comply. It's a judgment call.
Maybe we should ask one of the data brokers to come in and explain how long it will take. But the problem is that it doesn't take that long for one person, but it's the larger amount of people that it takes longer for folks to do that. And maybe setting up some sort of mechanism that would say, hey, you know, when one of these companies comes in and they send out 8,000, 10,000 different request forms, then, you know, the timeframes change. Because to remove, for me to email, you know, a company and say, please remove my data, me individually, takes a lot less time than if there's a company that's doing it for them and they're doing it all at once. I mean, that's my thought on that, because it is, you know, when it comes to volume, that's the case. I mean, I'm also cognitive that this is a small subset of Vermont, and it will be even smaller of the people that actually participate in it. And when I factor that in, are we creating the protection or are we creating a structure? And if we're creating a structure for lawsuits, then that's fine. I mean, it's an option of something that we can do as legislators, but I don't know.
Well, I'm hoping our motivation is setting something up to help covered people that we're talking about. Make sure that we're not, I mean, as far as I'm concerned, I don't want to stop anything.
And I'm not.
That's assisting in creating more lawsuits.
Right.
That's not, the motivation has to be, we're here to protect.
Right. And I apologize if I came across as saying that. It was a very emotionally charged issue because, I mean, I personally have felt like me bringing up concerns, I felt like I'm a terrible person for not caring about people. And that's not the case. But I don't know. Guess I just don't know.
And I think that's why you see we've gone to 15 days and we're creating a safe harbor for another 15 plus days in order for someone. The only issue in there is are the attorney fees that would be refunded enough for an entity to take this on? That's the question. But
So,
because I think it's, in my mind, safe to say that individuals there's gonna be very few individuals that would take this on themselves because it's just too massive. The companies are too big. We've already heard some of the things that they do for retaliation, so. You know, you're kind of caught between a rock and a hard place. Want to help the individuals, but the only way to help the individuals are businesses that are out there to provide that help, but it costs money to do that.
I'm not sure what progress of this is. It's really totally up to you and everybody. I would kind of like to see, the text of something. We haven't heard what the Attorney General is going to say, but it's a fairly standard type of legislative text in Title IX. So, gee, you do this, individual has the right. So it's pretty standard phrase. And, would help me to see that. Again, I don't know the timing of when things things are.
We don't have forever to keep working on.
That's what I figured, and that's why I was mentioning it. If you want to bring it to the head on Thursday or something, I'd like to see that language and see what people think about it.
Just have to determine what that language, what we want Rick to write.
I'm gonna write everything.
You're gonna write everything.
And you guys.
Give us a menu. A la carte.
Side by side by side by side. One from.
What I'm thinking of is, I've seen it in a number of different instances in Title IX. It's a fairly stock, they always make reference back to, I think, chapter 30 or something in Title IX. So the AGs have these remedies.
Talking about the Consumer Protection Act?
Yeah.
Well, we can't refer that because it's not a consumer protection bill. We can have similar language.
That's what.
Which is just, enforcement
Right.
mechanism, rulemaking. And then if you want to add a civil penalty, right of action. No.
Yeah, if I remember, the consumer protection says the AG can do some stuff and concurrently an individual can enforce their rights also.
Right.
Think about that idea.
Yeah, I like having both options for sure.
Let's see what that looks like.
So AG enforcement with a right of consumers also. So you want to add a civil penalty, specific amounts?
I would imagine that, but I didn't want to get ahead of.
I'll add it. I'll get ahead of you, Herb.
Schedules, but
Sometimes.
I didn't want to get ahead of it.
What about AG fines and individual liquidated damages? That's to both worlds.
Longer terms there. I mean, you continue to use the safe harbor right now.
Yeah. Yeah, I mean, ideally, everybody just does the thing in the 30 days and then they don't have to do any of this.
See what it looks like.
Okay.
Okay. Anything else?
A quick question, actually, on all of that. Back to the injunctions. So would somebody still have the option to, like, if something got really bad, like, and it was one of those, like, this person threatening me now, you can like prove it immediately, whatever. would that person be eligible for injunction if they had a provable?
In my mind, would.
Okay.
Yeah, but would it be a relief from abuse type order against that person?
Yeah,
Because at that
versus-
point, it's too late, right? They've already threatened.
Right, right.
But I think, the injunction piece is still there. Not- Okay, let's, if there's nothing else. Okay, tomorrow, 9 o'clock, we're gonna, probably hear, about CTE more. And then, have committee discussion on where you think we ought to go with that.
Siki.
Yeah. So if there's nothing else, I think we'll